Okay, can you please help me? Good afternoon, ladies and gentlemen. Welcome to Dr. Olu Asekun podcast. Thank you for joining us. Today is another beautiful Wednesday. We do this every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific, and that is 11 a.m. Mountain Time. And currently, I believe it should be about 6 p.m. Nigerian time. Hopefully, I got the timing right because of the changes in time between the US and Nigeria. So, welcome, welcome, welcome. Yeah, as usual, we will go over the recent updates, whatever update we have between last week and today, last Wednesday and today, and then we go straight into questions and answers. Today we are going to spend exactly 1 hour because it's really, really, really tight schedule. In fact, I just finished a court case now. I thought that I would not be able to start, but luckily I was able to finish just in time. So if you have questions, start sending them in while we discuss the update. The update will not take more than probably 5 minutes. Okay. Between last week, Wednesday, and today, not many things happened. We have both positive and negative news. Please invite your friends, family, colleagues at work to join us so that at least nobody misses out from this opportunity. As I said, positive news in that a lot of the immigration court or a lot of the immigration judges, they are already back to normal. They are acting and operating normally now the way they used to before the new Trump administration. We are able to have our ways the way we used to. We are able to have laxity. We are able to do things the way we normally do before the new administration came with all the scary uh, policies and all of that. So that's a positive news. The relatively negative news associated with it is that the DHS, that is the Department of Homeland Security, they are doing some things now that is very tricky. They are doing some things that is very, very tricky. Please, I'm going to advise, if you are in removal proceedings, ensure that you have a very good lawyer, a lawyer who understands the law and understands how to maneuver things at immigration court. What the government is doing now, initially I thought it was only in Dallas, but until AILA is American Immigration Lawyers Association, they also posted it. They posted it yesterday. So that's when I realized that this thing is not limited to Dallas. It's probably across the US. For people who are in removal proceedings, what the government is doing right now is that they will tell the judge, they will tell the immigration judge that they want to withdraw charges against the respondent, that the court should dismiss the charges, they should dismiss the removal proceedings. Now, as soon as the judge dismisses those removal proceedings, then plainclothes officers, they are going to approach that person, either inside the courtroom right there, or sometimes they wait outside the courtroom for that person to come out of the courtroom, and then they will pick the person up. This is a new trend. And according to American Immigration Lawyers Association, it is rampant. I saw it myself in Dallas, but I thought it was only a Dallas affair. I didn't realize it was national. But AILA has reported, American Immigration Lawyers Association have reported that it is actually all over the country they are doing that. In addition, they are also picking up people who have previous removal order or who have criminal conviction or even criminal charges or people they deemed have committed fraud, immigration fraud. They are arresting them at interviews. I witnessed one myself yesterday, although I didn't know the details. I didn't know the details of why this person was arrested, but all I'm just saying is that I witnessed people being arrested at the immigration office in Dallas yesterday. But from the report that we are getting from the American Immigration Lawyers Association, people who have previously been ordered removed, or people who have criminal record or who have criminal charges pending against them, or people that immigration determined they have committed immigration fraud. Those are the three sets of people that are being arrested at immigration offices. So my advice to you, if you have a case with USCIS and they invited you for interview, please, the first thing, if you have a lawyer, tell your lawyer. Even if you don't have a lawyer, find a way to check these things out before going to immigration office. I've stated it several times on this podcast. Go on Google, type EOIR case status. EOIR case status. Put in your alien number. It will tell you whether you have a removal order or not. If you have a removal order and you needed to attend interview, consult a very good immigration lawyer before going to immigration office. Otherwise, you may enter there and end up in detention. That is the new trend now. But if you have a good immigration lawyer, they know exactly what to do. I mean, I've been confronted with this multiple times this year after this new administration came. We know exactly what to do to prevent that arrest. But it is important that you know, because if you go in there unknowingly, you may end up in detention. So if you have an interview, the first thing you should do, go and check the EOIR case status. Check if you have a removal order against you or not. Because I've said it multiple times, it is possible that you may have a removal order and not know about it. If you move and notice to appear was mailed to your previous address and you didn't know, once the hearing notice is mailed and you didn't know, the judge is not going to wait for you. The judge is not even going to know whether you are aware or not. They may just think that you just choose not to show up. You choose to disregard the court. The judge is going to order you removed in absentia. So, I've seen people who move and then they go to post office to go and change their address. Changing address at the post office and changing address at immigration are not the same thing. Immigration documents are not forwarded. It is the law. That is the regulation. The post office are not authorized to forward immigration documents. So if you change your address at the post office and you do not change it with immigration, if they mail a document to your old address, the post office will not forward it. They will rather return it to immigration, and that may lead to in absentia removal order. So if you also have criminal cases, if you have pending criminal charges against you, before you go to immigration, talk to a very good lawyer who understands all these things. Otherwise, you may end up in detention. Something as simple as DWI gets automatic detention. Remember last week I mentioned Lincoln Riley Act. Once you are accused that was about stealing. Once you are accused of theft, it's a mandatory detention. DWI nowadays is mandatory detention because the immigration judge is going to rule that you are a danger to the community. So all these things, check it out before you go to immigration office so that you don't leave believing that you are going for an interview and then you end up in detention. Finally, before we go into questions today, The Secretary of Homeland Security have ordered the DHS to revoke Harvard University's ability to hire to admit international students. So I know that Harvard is probably going to challenge them in court, as they have been challenging all President Trump's targeted policies against them lately. But as of today, according to AILA, American Immigration Lawyers Association, the DHS secretary has instructed DHS to revoke Harvard's ability to admit international students. What that means is that even students who are currently on F1 status at Harvard, they are all going to be out of status except they transfer. They have to transfer immediately, otherwise they are going to be out of status. It's unfortunate that they are the students are the pawn in this game, but that is what is going on right now. So if you have a relative who is in Harvard or who is on student status at Harvard, I don't know what they need to do now, but probably if I were in that situation, I would start looking for a transfer opportunity before it is too late. I expect DHS, if they follow through, I expect them to give the student some time to be able to transfer. But again, under this administration, nothing is predictable, because I believe this is a personal vendetta between President Trump and Harvard University. So those are the updates for today. So we are going to start with the questions. Can you please start posting the questions? So we are going to start with the questions. Those are the updates for today. So be careful out there. Get a very good immigration lawyer if you are in removal proceedings before it is too late. In fact, I did something today in court. It's kind of funny, but I mean, it just shows that when you are good at this job, there's no other way to explain it other than you are good. I played a smart one on the DHS lawyer in court this morning. They wanted me to plead to the NTA. Of course, I knew that the judge may probably not want to even grant continuance if I requested continuance. So I decided to plead. I admitted allegations 1, 2, 3. Then I denied the allegation 4, which is the allegation of unlawful presence, that overstay, that after the expiration of the I-94, you remain in the United States without authorization. So I denied that charge because my client has a pending asylum application. I wasn't even sure if the application was filed on or before the expiration of the I-94. But I told the judge that I have a concern with this charge because I believe that my client filed asylum application before the expiration of the I-94. And if that is the case, it means that my client's presence in the United States is authorized by the Attorney General. I stated that law to destabilize the government lawyer. Guess what? It worked. The judge turned to the government lawyer. How do you respond? Of course, they don't have a response. So they now requested the judge to continue the case to another day, to give them time to upload documents and all of that. I mean, this is experience. Continuance is what I wanted, but I didn't request it. I played a fast one. Of course, I was playing with the law. I played a fast one on them. They fell for it because the lawyer is probably not as smart as I am when it comes to immigration law. So I played a fast one and it works. So it is very important to engage somebody who have a knowledge of this law that we practice. Immigration law sometimes can be complex, but at the same time, if you know it, you know it. Okay, let's go into questions today. So the first one, is it the one that says, good afternoon, Dr. Asekun? Okay. Is that a follow-up or just a greeting?
No, they're just greeting.
Okay, thank you. Good afternoon, too. The next one, good day, sir. Thank you for all you do. Thank you. Thank you. Next one, good afternoon, Dr. Asekun, sir. Thank you for your consistency and all you do. May God bless you real good. Amen. Thank you so much. Next one, does that mean anyone going to court proceedings will be arrested by ICE? No, no. What I'm saying is that if you go to court, if you have a hearing in court, number one, before you go, ensure that you know what relief you are going to be seeking. If you go to court and the government unsolicited offer to dismiss your case and you don't have a relief that you want to pursue or that is pending with USCIS, decline. That is my advice. Decline the offer of dismissal. Because what they are trying to do is that once the court dismiss the case, then they will be able to say that you don't have anything pending, so they can arrest you. So that is exact. They are playing a trick on people. But if you have a smart lawyer, if they offer unsolicited dismissal, you oppose it. Tell the court, no, you don't want the case to be dismissed. You want to present your relief in court. Even if the judge decided he was going to dismiss the case, you file your appeal. You tell the court that you are going to reserve appeal because you want your relief to be heard in court. They have already placed you in court. You want your relief to be heard in court. So that way you kind of keep your options, because you still have the ability to argue that you have a pending case. What they are just trying to do, I believe that in accordance with the president's policy of getting people out of the country fast, because that's the president's word, as fast as possible. So they believe that the removal proceedings is a long process that is going to delay them. They believe that it is a kind of a clog in the wheel of their progress. They don't want things that will delay them. So if you don't have a pending relief and then the case against you at the immigration court has been dismissed, then what is going to be keeping you here legally? Nothing. So now they have a reason to arrest you because you are here unlawfully. So that is what they are trying to achieve. So you don't fall into that trick. That is the point I'm making. That is the advice. So those who go to court without having lawyers, if you go to court under this current situation and they are telling you that, oh, you know what, we are going to dismiss the charge against you, it is a Greek gift. Don't accept it. That is what we are advising. Because to the best of my knowledge and from the information posted by AILA, American Immigration Lawyers Association, everyone who have been arrested in court last week, that is what happened. There are people either with removal order or people whose cases were dismissed at the request of the government. Of course, if you don't have a relief, you will also fall into that category, because once the judge asks you what relief are you seeking and you are not able to articulate any relief, then the judge will order you removed. And these ICE officers, they are wearing plain clothes, so you will not even know that they are ICE officers. That's the unfortunate part of it. You see, it is unfortunate that the government is really turning this thing to a kind of joke. Why will ICE officers now start disguising? Why? What is the government benefiting by doing that? They are now going to court in plain clothes. In plain clothes. They are not wearing uniform. So you will not even know, because usually when you go to court, especially for a master hearing, you see so many people in court. There are a lot of respondents who come to court. So how are you going to know who is an ICE officer and who is just there to defend his or herself? So they are wearing plain clothes. waiting for the decision in court. So if the judge order you removed, they already notice you, they wait for you outside the door. As you are stepping out, they arrest you. So that is what we are saying. We are not saying that everybody in court is being arrested. No, that is not what we are saying. Next question, please. Good morning, sir. If you applied for asylum, can you renew your passport when it's due and it's not going to affect your asylum decision? Well, it is not advisable to attempt to renew your passport in your home country. You see, asylum has a lot of special provisions, and one of them includes the issuance of a passport by the DHS, by the Department of Homeland Security. If you have a pending asylum application, if you apply for a travel document, they will issue you another passport that is issued by DHS. That passport allows you to travel to any country except your home country. So it serves the same purpose. So because if you are telling them that you are running away from your home country and the government of your country is unwilling or unable to protect you, and you are now applying to this same government for benefit, sometimes it raises issues. And again, let me tell you this. It also has its own benefit if you don't have a valid passport. It slows down deportation. It slows down removal because the DHS or ICE cannot remove anybody without a valid passport. So by getting a valid passport for them, you are actually expediting your own removal if your case ended up being denied. You are expediting your own removal. So if you have a pending asylum application, if I am in your shoes, I will not bother to apply to renew my passport. And if I needed to travel, I will use the DHS issued passport and use that to travel. Next question, please. Asking for a friend. The person is an asylee on removal proceedings with case dismissed in February 2025, though still has their valid work permit. Will my case be reopened, and what should be the person's worry? Well, I know that a couple of weeks now, in one of the podcasts, we mentioned that the DHS has notified us that they are going to reopen cases that were administratively closed. Now, there is something that I need to point out. There is a difference between dismissed cases and cases that are administratively closed. They are not the same thing. So the information provided to us was that DHS was going to reopen cases that were administratively closed, not cases that were dismissed. The difference between cases that were dismissed and cases that were administratively closed, when a case is administratively closed, removal proceedings is still pending. The removal proceedings has not been dismissed. Even if this person has any new relief, they cannot get green card through USCIS. They still have to go back to court and file a motion to reopen in order to apply for the new relief. That is for cases that are administratively closed. Now, cases that are dismissed, that case is dead. Even if the DHS decide to take you back to court, they will start the process all over again by issuing a brand new notice to appear. So there are two separate things. So from this question, if the case was dismissed in February, that is it. That case is closed. So just tell your friend to avoid anything that can bring him back to the attention of ICE. Let him lay low and especially not commit any criminal activities. Once somebody gets into criminal arrest right now, this administration they don't have the patience to wait for people to go through the process of their criminal case. Once there's an arrest, it's enough for them to detain people. That is what we have noticed. That is what they have been doing. Next question, please. Good day, sir. We appreciate the great work you are doing, sir. Thank you. I put in for VAWA in September, and in February, I got a 5-year EAD and parole. I want to seek your advice if it's all right to travel, sir. Oh, yes. For as long as you don't have criminal record. We have said it before. For people with VAWA, yes, you can travel. For as long as you don't have criminal record. Criminal record does not exempt anybody. So even if you have VAWA, if you have criminal record, I will not advise you to travel. But in the absence of criminal record, you can travel. Next question, please. Good afternoon, sir. Can a mother whom her child is filing for use her maiden name even though she is married? Well, in the application for adjustment of status, they will ask for all legal names. So there are so many questions, there are so many follow-up questions that I will have from this question. So what name is on the passport? So if you are still married, when you got married, did you change your name? So if you have your name, if you have your marital name on your passport, if you have your marital name on your visa, for you to change your name, you will either need a divorce document or proof of legal name change, because whatever name you have on your passport and your visa, that is your legal name. So if you are going to change it, there has to be a basis. It is not impossible to do. You can do it, but they will have to know why. You have to back it up with some form of document. But generally, in the application, they will ask you, what other names have you used? But if you have your marital name on your passport, you have your marital name on your visa, you have your marital name on your I-94, now if you file an application, you put a name that is completely different, you will have to show you are the same person. So there has to be a document that will show that you are the same person. So you can't just wake up and legally change your name. You can either change your name by marriage or by legal name change. So you have to provide some form of document to back it up. But if your maiden name is in your passport or your visa, yes, you can revert to your maiden name, even if you are not divorced. You can choose to do that. Next question. VAWA with parole should sit your bond down. Where you dey travel to? You know they hear word. No. VAWA can travel. VAWA can travel if there is no criminal record. Please note that if there is no criminal record. The reason, one of the reasons VAWA is not at risk is because, number one, for somebody who files for VAWA, there is a presumption that you are no longer with the abusive U.S. citizen spouse. So even if immigration have doubt about your marriage, they are not going to call your ex, they are not, or your U.S. citizen abusive spouse, they are not going to call him or her to ask any question. So it is just going to be about you. They will verify the document, the travel document you have upon re-entry. They will verify it. Once they verify it that they are the one that issue it, then they check whether you have criminal record or not. Once you don't have criminal record, you are okay. You can safely travel. There is no problem.
I have a question. Sorry.
Yeah.
Should the person with VAWA... Never mind. I just answered my own question. Don't mind me.
Okay. If you remember it, just write it down.
Yeah.
Okay. Next question. Good afternoon, doctor. I'm very lucky to subscribe to your channel. Thank you. I applied for my citizenship the day you addressed my case, and I have been scheduled for biometrics on 27th of this month. I will continue to give you the update. Hoping for the best. Thanks and God bless. Oh, thank you too. Thank you for the update. Last week question. Okay. Is a medical RFE a good sign for VAWA I-485 application? Will my interview still be waived? Oh yes, it's a good sign. In fact, lately we have been receiving a lot of green card without interview. We have received a lot and lot of green card. In fact, there is one that I least expected, because this particular one, the VAWA was denied like 2 times. We filed motion to reopen. They denied the second time. We filed the motion to reopen. They denied multiple times. But we kept on filing, pointing out that immigration was wrong and so at the end of the day, they approved the VAWA. So because of all the complications and all the issues the VAWA raised before it was finally approved, I had hoped that they were going to invite that client for interview. But surprisingly, just yesterday, we received the green card. Interview was waived. Yes, if they ask you for medical, it's a good sign. Because right now, another thing that I discovered is that VAWA office is no longer transferring the I-485 to local office. They are adjudicating it themselves. So it's a positive sign. Next question. Okay, EAD expired and another card has not been sent presently. I'm not working. Can I get approved for SNAP or any food benefit with prima facie? I hope it won't affect my VAWA approval. No, prima facie determination has nothing to do with VAWA approval. In fact, it is the same VAWA office that issue prima facie determination. However, what you can do is that once you have applied for the renewal of your EAD, the receipt notice should give you 540 days automatic extension. So you can use the combination of the receipt notice, the expired EAD, and the prima facie letter to apply for your benefit. But yes, it doesn't affect VAWA approval. Next question, please. Thank you, sir, for all you do. We have filed our I-485 and 765 under VAWA, but didn't submit our medical report. Should we now send it on its own or wait to get a response from them? Will not submitting, is there a follow-up?
This is okay. Yes. The medical report.
Okay, will not submitting the medical report work against us? Well, it's not going to work against you per se, but I believe that if immigration finds that medical report is not there, they will issue a request for evidence for it. The only concern I have about sending it unsolicited is that documents get lost. In fact, I did an interview yesterday. At that interview, I believe in January, earlier this year, USCIS had issued a request for evidence asking for the medical examination. So we provided the medical examination and we attached it to the copy of the RFE letter and mailed back to USCIS. But during the interview yesterday, the officer said that he didn't receive the RFE. I argue with the officer. I even show proof of delivery that, look, we sent it to the office that requested it. But the problem is that RFE came from the National Benefit Center in Missouri. The interview was conducted in Dallas here. So the officer has the file. The medical examination report was not there. So the officer said that, well, I'm not disputing that you sent it. All I'm just saying is that I don't have it. And without having it, there's no way I can approve this case. So at the end of the day, I told the officer that my client will have to provide a new one to prevent additional delay. But luckily, at the end of the interview, the officer was able to locate the medical examination. It was uploaded in the wrong place. So the officer was able to locate it. So that now prevented the need to send a new one. So the challenge is when you send unsolicited documents to USCIS, the probability that it will get into your file is like maybe 50%. Because if they issue an RFE, it will have a barcode. That was part of what I told the officer, that, look, why don't you scan the barcode so that you will be able to trace it? So if they issue an RFE, the RFE letter will tell you specifically where to mail the response. But if you just send it on your own, you probably will just send it to the address on the receipt notice. But your case may not even be handled by the same officer. Your case may be in a different unit. So it is possible that they may get it, but it is also possible that they may not get it. So since you have already filed and you didn't include the medical, if I were in your shoe, I would rather wait until they issue an RFE and then I will send it, so that you know that there will be a barcode that comes with the RFE letter. That way, the document is unlikely to be lost in transit. Next question, please. Okay. Hi, Dr. Olu Asekun. My son filed for his father, and the father got his green card in 2024. But as of January 1st, 2025, his son joined the Air Force and now an active member of the armed forces. Can the father get citizenship before his 5 years waiting period? Oh yes. Immediate family of active military members, they are required to be a permanent resident for 1 day before being eligible for citizenship. Yes, since is the father of an active military personnel, yes, is eligible for citizenship. Next question. Good day, sir. I entered without inspection, married to a U.S. citizen. Will you recommend to file I-130 and I-601 waiver now, or what can I do? No, that's not the there is no waiver that can waive your entry without inspection. What you will need to do, but you have to really consider your option, because with everything we have been seeing lately, you may be in a very precarious situation. What you need to do, let your U.S. citizen spouse file I-130 petition, stand alone for you. You can't file I-601 waiver until after the I-130 has been approved. For you to file I-601A, I-130 has to be approved first, and you have to pay immigrant visa fee first before you can apply for I-601A. Those are part of the requirement, because when the I-130 is approved, that will show that immigrant visa is immediately available. When you pay the immigrant visa fee to the National Visa Center, that will show good faith intention to depart the United States. So it is only after that you can file the I-601A waiver, unlawful presence waiver. And when that waiver is approved, you will still need to return to your home country in order to apply for immigrant visa at the U.S. Embassy. Somebody who entered the United States, there is no waiver that can make you get green card in the U.S., except if you are eligible for cancellation of removal. Next question, please.
Someone is thanking you for the answer.
Oh, thank you too. We appreciate it. The next question. Good afternoon, sir. May God continue to strengthen you and your entire team. Amen. Sir, as a U.S. citizen, I filed I-130 for my 2 kids in Nigeria since September 2024, and we are yet to hear any information. Please, when is it likely to hear from USCIS? Can you please quickly check the processing time? Immediate family of a U.S. I-130 consular processing, immediate family of a U.S. citizen. Please go to the next question while we are checking the processing time. Okay. I will come back to answer that question once we check the processing time for you. The next question. Good day, sir. Thank you for your wonderful work. Thank you. Sir, my priority date for EB2NIW will be current by next month. Planning to file for AOS. My spouse is yet to join me here in the US. And I wish to know the best and fastest way she could get her green card. I included her in my I-140. Well, I'm assuming that this I-140 has already been approved. And secondly, you can't even be sure that your priority date will be next month. Priority date is not something that is month by month. Sometimes it is something that fluctuates. Sometimes it moves forward, sometimes it retrogresses. This month, it moved forward like 3 months. So,
Maybe they mean June?
what?
Maybe they mean like they checked the June visa.
Yeah, but it's projecting that his visa is going to be current next month. How do you know that? That's not something you can know because sometimes visa can retrogress. The June bulletin is already out and visa move forward by 3 months. But July can come back, the thing can retrogress even 4 or 5 months. We've seen that happen before. In fact, if you look at the religious visa category, when it was going to retrogress last year, it retrogressed by 3 years. And currently, they are back to 2019, even though visa was current in that category as recently as 2023. So it's not something that you can predict that, okay, because they are currently in June 2023, by next month they are going to be in July 2023. No, that's not the way visa bulletin works.
But I'm saying maybe because this was posted last week, maybe they meant like, oh, based on the June visa bulletin, I can file now because it's current.
Well, the question says that it's going to be current next month. It says it's going to be current next month. Well, if the visa is current, if your spouse is not here, the only thing you can do for your spouse is follow to join. So go ahead, apply for adjustment of status for yourself. Of course, list your spouse's name in your application for adjustment of status. Then thereafter, after you get your own green card, you file I-824, application for action on an approved petition. So once that one is approved, they will forward your file to the National Visa Center, and then your wife will be able to apply for immigrant visa. But if your wife is able to get visiting visa or any kind of visa and get to the US before your green card is approved, at any stage, even if you have already applied for your green card, for as long as your wife gets to the US legally before your green card is approved, your spouse can still apply for adjustment of status. But if your green card is approved before she gets here, then she will have to apply for consular processing, follow to join, except if you now convert it to a family petition and you file an I-130 petition for her, assuming that she's in status and visa is current. Next question, please.
Going back to the processing
The
time,
processing time, yeah, for children of USC.
it's anywhere from 17 to 66 months right now.
Is it based on different service center?
Yeah, all service centers, except for National Benefits Center, is 17 months.
17 months?
National Benefits Center is 53 months.
Oh.
Yeah. All field offices, 66.5 months.
Well, this is not going to be in the field office because the beneficiary is they are out of the country. So it's going to be one of the service centers or national benefit center. Well, if the writer of the question is still online, you may look at your receipt notice and tell us where your petition is pending. If it is pending in any of the service center, the current processing time is 17 months. But if it gets to National Benefit Center, those ones are something else, 54 months. So the next question. Thank you. I want to apply for I-485 NIWEB. My wife is currently working on moving to UK for her study from Nigeria. Should I wait for her to be there before I apply for I-824 for her?
There's different questions for the same person.
Okay.
This is two. But maybe you want to address that one.
Yeah, let me answer the first one first. Well, first and foremost, you cannot even apply for NIW together with adjustment. It's not current. That's not the way it works. You have to file the I-140 first. The day you file the I-140, the day immigration received it, that is the day you get on the queue. That is what is called priority date. You cannot file I-485 until your priority date becomes current. So you can only file the NIW petition, file your I-140, and wait for it to be approved. Upon approval, you wait for the visa to be current. So when your visa becomes current, that's when you can now think about where is your wife. Of course, when your wife is, if your wife is not in the US, that's when you do follow to join. But if your wife is in the US, you can apply for green card for both of you. But if she's not in the US, you still cannot. You have to get your own green card first before you can file the I-824. And if you are going to file the I-824 and request that they process it in the UK, assuming your wife is in the UK, she will have to be maintaining legal status in the UK. And that is not visiting visa. It has to be a form of resident permit. Next question.
That's the second question.
Okay, the second question from the same person. Okay. Yeah. Do I have to apply for change of address at a point because I use Nigeria for her when I apply for NIW, and I will be using Nigeria as her address while filing for I-485? I assume that's what the person... Okay, I think this person has probably filed the I-140.
Yes.
Because it said when I applied. Okay, so if you already have an approved I-140, go ahead and apply for 485, which is the application for green card. So if she's legal in the UK, you can use UK address for her. But if she's not legal in the UK, then she will have to go back to Nigeria in order to process the immigrant visa. Because the US Embassy, anywhere in the world, they will not entertain an applicant who is not legal in any foreign country. They will not entertain that. So she will have to go back to Nigeria except she is legal in the UK. And like I said before, legal does not include visiting visa. If all she has is a UK visiting visa, the embassy will still not process her immigrant visa at the US Embassy in UK. She will have to return to Nigeria. But whether you use UK address or Nigerian address, in the application for immigrant visa, they are still going to ask for your address in the last 5 years. So she will still have to provide both addresses if she has lived in the UK. Next question, please.
That's the third question from the person.
Okay, third question from the same person. Okay. If at all she wants to apply for F1, F2 visa to come visit me or study, in DS 160, there is a question: has someone filed an immigrant petition for you? Is the answer yes if the husband filed I-485 here? The answer is no. The answer is no, because she cannot file I-485 from outside the country. Only you can file the I-485. But of course, I know that in the DS 160, if I recollect correctly, there's another question that will say, do you have any family member in the US who is either a US citizen or a permanent resident? Then she will, well, if your green card has been approved, she will have to say yes to that question. But if your green card is still pending, she can still say no to the question, depending on the timing. Next question, please.
Okay, now let me go back up to where his first question was. Okay, so this is the next one then.
Okay. It's a
Skip it. We've already done this one.
Oh, you have? Okay.
Yeah.
And also this part two. So this will be the next one.
okay.
Because that person sent it after I had posted it from last week.
Okay.
Okay.
Yeah.
Hello, sir. Please, does becoming a dependent on a new spouse pending asylum mean one automatically lose his current status, e.g. H1, F1, or J1? No, it does not. It does not. You maintain your H1B or F1 or J1. You maintain your status. You only lose that status if, for example, you are on F1. If you stop going to school, you will lose that status. If you are on H1B, if you stop working for the employer, you will lose the status. But by mere the fact that your name is listed as the spouse of somebody who applied for asylum does not kick you out of status and does not automatically make you lose your status. No. In actual fact, it is to your benefit to maintain your status so that if for any reason the asylum is not approved, they will not place you in removal proceedings. The next question. Sir, greater work from you and your team. Thank you. I entered the US with B2 May 2024. My I-94 expired November 2024 and applied for asylum a few days after. Am I in illegal? I don't get this question. Few days after which of them? After the expiration?
Yeah, I think after the expiration.
Okay, let me get the fact again. I entered May 2024. The I-94 expired November 2024 and applied for asylum a few days after. So I'm assuming a few days after November 2024. Yes, you are not in legal status and you are not lawfully present.
And then this is part two. The one underneath.
Okay. Part 2. Is it possible to now change from asylum seekers to religious workers? R1. Oh, is this the same person?
Yes.
If this person is already out of status, no, you are already out of status. You cannot change to R1. Because you see, that law, what that law does is to freeze your status. So it has to be before the expiration of your I-94. Once the I-94 is already expired, then there's nothing to freeze. So it is, once it's expired, that's it. You have to file your asylum before the expiration of your I-94 in order to take benefit of that provision of the law. Next question, please. Good morning from here. Please, sir, is there any problem filing for adopted children from Nigeria? Well, I don't know what you mean by any problem, but there are so many procedural challenges because I always say it, and I've said it several times on this platform. Less than 10% of adoption cases from Nigeria are approved. Less than 10%. And the reason is very simple. There are specific rules when it comes to asylum. Number 2, Nigeria as a country is not a member of the Hague Convention. Nigeria as a country is not a member of the Hague Convention. If Nigeria were to be a member of the Hague Convention, many of the problems associated with adoption from Nigeria would have been solved. However, still, there are 2 ways to process adoption from Nigeria. The U.S. citizen applicant, of course, this is only applicable to U.S. citizen, not for any other person. If you are not a U.S. citizen, there is only one way. You don't have the second option. But for U.S. citizen, there are only 2 ways. The first one, you apply for advance permission from USCIS here. So that will require you to get a home study. There are some organizations that are authorized by the Department of State to conduct home study. They will come to your house, verify what you do a background check on you, verify that your house is conducive for the adopted child, that if the child comes to the US, that child will not be a liability to the government. And they will do all those things and write a detailed report. So you apply for advance permission. Now, once that permission is granted, then you travel to Nigeria. You go and identify a child that you want to adopt. But of course, the child must be an orphan. You cannot adopt any other child under using this procedure. This one is only applicable to orphans. So that child must be an orphan. So once you identify the child, you apply for adoption, and then you notify the US Embassy that you have identified a child, and then you present the adoption document to the embassy, and then the embassy will process a visa for that child, and then that child come back with you to the US, and that child will be automatic US citizen. You don't even need to apply for green card for that child. So that is one procedure. Now, the second procedure is that as a Nigerian yourself, or even if you are a foreigner, you go through the adoption agencies in Nigeria, go through the court process, get the adoption granted, and then process an I-130 petition for this child to come to the US as a family member, as an adopted child. But here is the problem. This is where the challenges come. There is a lot of problem with child trafficking, not only in Nigeria, but across the world, even including the US. There's a lot of child trafficking going on. And the US government is actively trying everything within their power to stop child trafficking. So they ensure that every law relating to adoption is complied with. The challenge for US citizens or people living in the US is that many of these procedures require them to be physically living in Nigeria. And you and I know that not many people can leave their bills behind and go and live in Nigeria. So many people ended up having family members either help them with their adoption, or even when they travel to Nigeria, get the temporary adoption, they leave that child with a family member, and then they return to the US. Now, at the end of the process, even despite all the approvals from here, the embassy will deny it. That is why it is becoming challenging from Nigeria. Not that there is something special, but it is becoming challenging. So if you are going to do it, it is better to do it as a US citizen who is adopting an orphan. So that way, you do your home study from here, you file the advance permission with the USCIS, get it approved, go to Nigeria, identify an orphan, and then come back and complete the process. That is much easier. Next question, please. Okay. From my understanding, based on your explanation concerning filing asylum application late after I-94 expire or after 1 year of entry, does that mean that the applicant is likely to be deported by judge? Is FGM a strong asylum case for someone who filed asylum after 1 year of entry and was sent to immigration court proceedings? Well, as I always say on this podcast, immigration law is not a one-cap-fits-all. Every case is different. When you look at the application for asylum, the form I-589, there are multiple things that this form is used for. One is asylum. Second one is protection under CAT, Convention Against Torture. Another one is withholding of removal. Now, each one of these things have their independent requirement. The requirement for asylum is different from the requirement for withholding of removal. The requirement for withholding of removal and asylum is different from the requirement of protection under Convention Against Torture. Even though it is the same asylum application that you will use for all of this, but their requirements are different. Now, out of these three, it is only asylum that requires that you apply within 1 year of entry. That is the only one. The other two, withholding of removal and protection under Convention Against Torture, they do not require 1 year deadline. Therefore, going back to your question, does it mean that anyone who applies for asylum is going to be deported if they didn't file their asylum application within 1 year? Not necessarily. Probability of being denied asylum, yes, that one is 99% that the asylum is going to be denied if it is not filed within 1 year. That is 99%. Are they going to be deported? That depends on the fact of each case. Because somebody who is not eligible for asylum because they didn't apply on time may be eligible for withholding of removal or be eligible for protection under Convention Against Torture. Going back to FGM, I think that is the B part of the question. Going back to FGM, is FGM a strong asylum case for someone who filed asylum after 1 year of entry? No, it is not, because the fact that you have FGM, either you have been circumcised or you have fear of being circumcised, that does not mean you should not file your asylum within 1 year. Does it mean that you will be eligible for withholding of removal? Again, it depends on the fact of each case. I have represented clients in removal proceedings where asylum was denied because they didn't apply within 1 year, but I was still able to get withholding of removal even based on the same FGM. So the fact of each case is different, and of course, presentation matters. Lawyers matters. Whoever is representing you matters. The same FGM that somebody will present and get denied, another person will present the same FGM and get approved. So it depends on how good you present your case. But can FGM grant you 1 year exception for filing asylum? No. Can FGM be basis for withholding of removal? Yes. Especially if you have a strong case. Yes. Next question, please. At least that is something I have done successfully multiple times. Yes.
Okay, so this person here, they wanted to start the question, but then they posted it later, so let me go to it, okay?
Okay.
This one, yeah.
Okay. Hello, sir. Asking for a friend who has a pending vow and is now married. Withdrawal notice sent to USCIS but not acknowledged, but rather got an RFE. What do you advise? Reply to the RFE. Well, depending on what issue the RFE is addressing. You see, this is one of the reasons why I always advise my client. Every case is different. Please do not use one cap fit all for an immigration case. Every case is different. Now, this person got married. That is going to be a ground for denial of the vow, because once you get married while a vow application or a vow petition is pending, that application is going to be denied by operation of law. Now, the issue of the RFE, that is something completely different. For example, what is the issue raised in the RFE? If, for example, the RFE raised the issue of validity of the marriage or raised the issue of 204C, getting married to another person is not going to solve that problem. So you still want to address it, even though you are withdrawing your case, but you still want to address it. So if the RFE in your VAWA is accusing you of credibility concern, that is not something that you can ignore on the basis of, oh, you have now remarried, you want to withdraw. No, you have to address it. So you should address it that, look, my petition is credible. Even though I want to withdraw this case and I've notified you that I've remarried, therefore I intend to withdraw this case. However, I want to address the concern about my credibility. This is the issue you have raised. This is my response to show that I'm credible. So that is the right way to approach it. Because if you just say, oh, after all, you have withdrawn it. Yes, you withdraw it, but the new marriage, if your spouse file a petition for you, then USCIS is going to raise 204C issue. 204C is a major concern when it comes to family petition, because Section 204C of the immigration law says that no petition shall be approved if the alien has previously been accorded or has sought to be accorded a preference status as the citizen of the as the spouse of a citizen of the United States or an alien lawfully admitted for permanent residence by reason of a marriage determined by the Attorney General to have been entered into for the purpose of evading the immigration laws, or the Attorney General has determined that the alien has attempted or conspired to enter into a marriage for the purpose of evading immigration law. So your withdrawal, if such an issue is raised, your withdrawal is just going to postpone the evil day. So it's better to address it with the VAWA office. Even though you are withdrawing your petition, you address it. But if the RFE is just something completely minor, maybe they are asking for medical and all of that, of course, you can respond to the RFE by saying that, oh, sorry, we already wrote you a letter withdrawing this petition, so we don't want to pursue it. So it depends on the content of the RFE. Next question, please. Good day, Dr. Asekun. Thank you for all you do. Thank you. Question 1. Do I need police clearance to apply for adjustment of status by marriage? I'm from Nigeria and my interview is this week. No, you do not need police clearance. If you are physically present in the US, that is why they always call for fingerprinting. So once you file your adjustment, they will send you a letter asking you to go for fingerprinting, biometrics. So they will find out themselves whatever criminal record, if any, you have. So you don't need any police clearance report. Police clearance is only relevant if you need to apply from the embassy. That's the second question. Okay. Okay, question 2. I just discovered that I omitted my daughter's date of birth in I-485. Do I raise it or wait for the interviewer to raise it? If you submitted your daughter's birth certificate, they will find out and fix it. And if your case is the type that requires interview, during interview too, it can be fixed. So you really don't need to do anything. Just leave that for the way it is. Question 3. Can we take my 9-month-old baby from this marriage to the interview with us? Oh yes, you can take your child with you. Sure. I mean, that is additional evidence that your relationship is real. Yeah, you can do that. Question 4 from the same person. I noticed that the surgeon did not tick the polio and hepatitis B. I asked her to prepare another I-693 form so I could take it to my interview. What do you suggest? How do you know what was? It's supposed to be in a sealed envelope. How do you know what was? Okay, if this is from your copy, yeah, of course, that is something that has to be done. So Take it back to them and make sure you get the right one before you attend your interview. Otherwise, they may issue an RFE, and that may further delay your case. Next question, please. Okay. Is this part one or what was it?
Yes, part one.
Part one, okay. Thank you. Hello, sir. If someone with 2 years green card conditional is having serious issue with her partner that is getting irreconcilable, are there options for them to remove the condition on their green card without their spouse when the time comes under the current administration, spouse threatening divorce? Yes, as I always say, every case is different. In fact, there are multiple options, not only one, there are multiple options. But all of the options rely on one thing, and that is validity of the marriage. You see, immigration law does not require that a marriage must work. It is the religion that requires that, morality that requires that. I mean, Bible, for example, do not expect two people to divorce. They expect people once married to remain together. Morality also requires that. But the law does not require that a marriage must work. What the law requires is that at the time you enter into the marriage, it must be in good faith. So, yes, what you need to do is to show evidence that your marriage was in good faith. That is all you need to do. You can get the condition removed on your own, but you need documentary evidence to show that your marriage is in good faith, especially evidence that you obtained after the conditional green card was granted. I've seen situations where immigration have issues with the same document that were submitted before the conditional green card was approved. So you have to show that, okay, even after the conditional green card was approved, at least you still live together. So if you have evidence of joint commingling of assets, I'm sure that it is not the same day that your green card was approved that you started having problem, even if it is 1 month after, 2 months after. But at least evidence that after the green card, you are still living together in marital union. But is it possible? Yes. Multiple options, not even one way. Multiple ways. Possible, yes. Next question, please.
Okay, this one has been answered. This one.
Okay, good afternoon, sir. God bless you for everything. You have been a great encouragement. Thank you. And actually, this is also an encouragement for us. Next question. Sir, please, is it true that F1 students can travel to Canada, Mexico, and adjacent islands even if their visa has expired but they have a valid I-20 and are in status? Is it advisable to travel? No, it is not true. It is not true. Canada is a foreign country. It's not part of the United States. Or don't be deceived by Donald Trump's attempt to make Canada the 51st state. Canada is a completely different country. Mexico is a completely different country. So if you are coming to the US from Canada or from Mexico or from any adjacent island, you must show a valid visa. Your I-20 is not a visa. Your I-20 keeps you in status in the US. It does not allow you to enter the US. So don't fall for it. The answer is no. It is not true. Next question, please. So before I go to the next question, let me follow up that previous question. If you are planning to travel to Canada, then you need to schedule an appointment with the US Embassy in Canada so that when you go to Canada, then you apply for F1 status, F1 visa at the US Embassy in Canada. But of course, if you are denied, then you get stuck in Canada. Next question. Good day, sir. Thank you for the good work. Thank you. God bless you. Amen. My question is, when someone is out of status, does that make the person illegal in the country? Thank you. Well, it's not that straightforward. It's not that straightforward because the word illegal is complex. It's complex. When somebody is out of status, it means that you are not maintaining legal status. Now, is it everyone who has been out of status at one point or the other that are illegal? No. What if you have applied for relief? For example, even if you have been out of status and you subsequently apply for asylum, now, because you have a pending asylum, you will not be considered illegal until the asylum application is denied, which of course is going to be denied, especially if you didn't apply within 1 year. But until that application is denied, you are not going to be considered illegal. There's a difference between being illegal and being out of status. And that is why I keep emphasizing lawful status versus lawful presence. You have been out of status. At that moment, you are illegal. Now, if you subsequently submit an application for asylum, are you illegal within that point? You have a temporary protection until the asylum application is determined. But if you enter the US without a visa, this is not somebody getting out of status. From day one, you are illegal. That is different. So you cannot turn an illegality to legal. So by entering the US without a visa, that one is illegal from day one. So are you legal in the country? No. Next question. Some of these things are a little technical. I hope people are understanding my explanations. My asylum case is in court, but I want to change my case to marriage because I'm married to an American. How do I go about it? Well, your court case is not going to change your case. What you just need to do is to tell your American citizen spouse to file I-130 petition on your behalf. File that petition with USCIS, get the receipt notice, then prepare a package, include the I-130 petition, include the receipt notice, include evidence of commingling of assets, evidence of good faith marriage, evidence that you are living together with your spouse. File all this application package with the court and let the court know that in addition to the asylum, you now have another relief, and that if the I-130 is approved, you prefer to go for that new relief. But of course, the court is going to review the document that you filed, because before now, once you have a pending I-130, that could be a ground for your case to be continued until whenever USCIS is ready or they approve the I-130 petition. But nowadays, the BIA, the Board of Immigration Appeal, has ruled that immigration court can actually look at the validity of your marriage in determining whether to grant continuance or not. Next question, please. During master hearing in court, is it a good idea for the immigration lawyer to request for continuation of case by asking for the individual hearing for an asylum? Well, it depends on the court. Every case is different and every judge is different. The judges, they have guidelines, but they don't operate the same way. For example, there are some judges that will close the record before they will give you individual hearing date. So if you are going to appear before such a judge, make sure that all your document is ready before you request for individual hearing date. Because once the record is closed, it means that no, they will not accept any document from you until the day of the even on the day of the individual hearing. The record is closed, no additional document will be admitted. But if it is a judge that sets a deadline, submission deadline, the practice manual says that all documents you want the court to consider must be submitted at least 15 days before the hearing date. But some judges may set a different deadline. Some judges can tell you, okay, if you are going to submit any document, it must be submitted at least 30 days before the deadline. So it depends, a lot depends on the individual judge and the particular court. But naturally, for me, if your document is not ready, I will not advise you to request individual hearing date. Because if you do, and then you fail to provide those documents within the deadline or within the practice manual, it can work against you. And again, I've seen judges who are very strict when it comes to deadlines. What is the point of submitting a document that will not be considered in your case? So it doesn't make sense. Next question, please. And before I go into the next question, and I think that maybe I should chip this in. I don't know whoever asked this question, whether this person was part of this podcast at the beginning when I was discussing the smart move I made in court this morning. This is something similar. That particular court, it is one of those judges that closes their record. The case I did this morning, it is one of those judges that closes their record. So I knew that, and I knew that my documents were not ready. So when the judge asked me to plead, as I said at the beginning, I decided to play a smart one on the government lawyer. I mean, I have over 32 years of experience, so what do you expect? So I played a smart one on the government lawyer. So I denied one of the allegations, especially the allegation of unlawful presence or the allegation of overstay. So I denied that allegation, and I cited the regulation that stated that an asylum applicant, the status of an asylum applicant is frozen as soon as the application was submitted prior to the expiration of the I-94. Even though in my particular case, I wasn't even sure that the application was filed before the expiration of the I-94. But I threw in that argument, knowing that many of these government lawyers, they are not that vast with immigration law. I suspected, and it turns out to be accurate, I suspected that the lawyer will not know how to respond. So I threw in that argument. So the judge turned to the government lawyer. How do you respond? Of course, the government lawyer didn't have an answer. So it was now the government who requested a continuance. And of course, I didn't oppose it because that was what I wanted in the first place. But I didn't want to ask for it because it is possible that if I had asked for it, the government lawyer would have opposed it. So I just played a smart one on them, put them on the defense, and now they are the one asking for continuance. Next question. Good afternoon, sir. Please, I have 10 years green card and I divorced my wife 2 months before she passed away. Oh my God, sorry about that. Can I go ahead and apply for my citizenship? Well, if your wife already passed away and you are already divorced, either of the two trigger 5 years citizenship, 5 years citizenship requirement. Even if your wife is still alive, the moment you file for divorce, you have to wait 5 years from the date of your green card before applying for citizenship. So now that your wife is dead, you still have to wait for 5 years too before you can apply for citizenship. So even if you are still married and you are not divorced and you are living together, if she passed, if she died, you still have to wait for 5 years before you can be eligible for citizenship, except you join the military. That's the only exception. But if you have accrued the 5 years, then you can go ahead and apply for your citizenship. Otherwise, you have to wait 5 years from the date of your green card. Next question, please. Hi, can immigration officer revoke someone's asylum approved by immigration judge? No way. No way. They cannot. They cannot. However, they can file a motion to reopen in court and present any new evidence that they have so that the judge can reopen the case and then revoke it. But an officer cannot revoke something that is granted by the immigration judge. No. Next question, please. Hi, Dr. Asekun. As a U.S. citizen, it's already 1:30. Oh, okay.
We already put that we were stopping questions a while ago.
Okay. Okay. Hi, Dr. Asekun. As a U.S. citizen, would you advise that I file for my mom's LPR while she's on a visitor's visa, or should I go through the consular processing? This is a no-brainer. Don't even try the consular processing. If she's here on visiting visa, put in your application right away. That is your best bet. Because I can guarantee you, if your mom is here on visiting visa, if you apply for her her green card, it probably will be approved within 6 months. If you embark on consular processing, it's going to take you several years. Next question, please. Good afternoon, sir. God bless you richly for all you do. Amen. Please, I want to make an inquiry. I marry a citizen and I have a 10-year... What?
That's you just answered that.
No, she answered this one. She answered this one.
No, the one before that. Before a few questions ago.
No, I've not answered it.
Okay.
That one is talking about divorcing his wife. It's not that one. This is a different one. Okay, let me read the question again.
Yeah, you answered this one already. He posted it on the chat and he also sent it by text. You did already.
Okay,
Yeah.
okay.
Yeah.
And that's the last one.
Okay, and that's the last one, yes.
This one is the last one.
This one was the last one.
Oh, okay.
Yes.
So
We're done.
Okay, thank you again, everybody, for joining us. I was informed that was the last question for today. As you already see that we have been on this now for 1.5 hours, so it's been a very busy day as usual, so we have to end here. One thing I want our viewers to understand is that we receive questions daily, tons and tons of questions. Even apart from the podcast, some people send us questions through emails and all of that. We are trying our best to answer as many questions as possible. But the truth of the matter is that even if I sit in front of the computer from now till tomorrow, we cannot exhaust all the questions. So at a point, we still have to stop. We hope that God will continue to grant us good health and the ability to continue doing this on a weekly basis as we desire. So we hope to see you again next week. Until then, stay safe and be careful.